afternoon and welcome to another 29th meeting of Study Circle. I now call upon Mr. Rishikesh to give an introduction to the resource person of the day. Thank you.
Good evening, ladies and gentlemen. We have among us Justice K. Kannan. Justice K. Kannan, as we all know, was a practicing lawyer among us from Chennai and later elevated as judge of the Punjab and Haryana High Court in the year 2008. And the Punjab and Haryana High Court, as we all know, had the benefit of his immense knowledge until his retirement in the year 2016. A multifaceted personality, Justice Kannan is an author and has penned several books, some of which are Accidents and Compensation Law, Wills and Succession, Landlord and Tenant, Principles of Insurance, and is also editor of Modi's textbook on medical jurisprudence and toxicology, Mullah's India's Registration Act, Sales of Goods Act, Indian Succession Act, Medicine and Law, and he also contributed immensely to the Halsbury laws of India. Justice Kannan, as we all know, is a trained mediator and writes for leading newspapers on socio-legal issues and is a proud author of several articles. Post-retirement, he was also the chairman of Railways Claim Tribunal in New Delhi. He was, as we all know, he's a music lover, especially of the Carnatic, and is an avid blogger since Jan 2006. And his blog, Declaration of Assets by Judges, created a ripple among the judiciary. Justice Kannan was one of the first judges in India to declare his assets and brought a new paradigm shift for the entire judiciary to follow. In fact, in India Today, a famous magazine named him as one of the top heroes of the year 2009. I'll end my welcome speech with a quote of Justice Markandeya Kachchu, former retired Supreme Court judge and our retired Chief Justice. I quote, Justice K. Kannan was transferred out of Madras High Court to Punjab and Haryana High Court for all wrong reasons. He has fine reputation and checked with anybody. He would have raised the standards if he had continued. A true jewel, I unquote. Ladies and gentlemen, we not only have a true jewel, we have a scholarly jewel, and I don't want to waste any further time. And I open this debate or the presentation to Justice Kannan to take over. Thank you. I welcome you, sir.
Well, thank you so much for such extraordinary words. I'd rather wish that I had not made a presentation and then allowed the Kajju statement to go on. But then Justice Kajju makes all kinds of statements these days. Too sure whether everyone takes it very seriously. Anyway, it's a pleasure to see some of the persons, the known faces that I see, and that there could be an occasion like this when we could be meeting virtually and also talking about law. That was the last thing that I ever imagined. I would have thought about having a nice cup of coffee or tea with Shivaji on any day in the evening, but then to be talking about law, all right. Now, it's fun all the same. I've been now speaking to several lawyers from several parts of India these few days, and I noticed that all across the board there is a huge interest of persons getting connected to law and discussing law. The best of things to happen for sure. So that is the way the human civilization goes about, that we make out of adverse situations always something to improve. And why this topic registration, I'm not too sure. You must ask Om Prakash what it was. Probably he thought amongst other titles, I've done this as well. So when he was asking, I thought I would take up the issues on Registration Act for a reason that it's a legislation which brings a kind of authenticity to transactions, and it is the only way by which any public has an access to obtaining information of how a person has acquired properties, and the public policies are made on that. We had different jurisdictions as well. Actually, just I thought I would open up with that in the continental jurisprudence, or what was applied in India, in some portions of India, like Pondicherry, Pondicherry, the state of Pondicherry had other places as well. In Goa, again, the court civil where it was, they had an approach that called as Bureau the Authentic. Bureau the Authentic is that place which authenticates something, and the authentication is such that it is a proof of valid title itself. Any transaction which is made, if somebody says, I'm not bound, I'm not a party to the transaction, you will be losing the right to the property itself. All transactions have to be written by a person who is called as a notaire. Notaire is someone more than a notary public. Because I see Sivashanmu there with their office, they have fairly good understanding of what is happening from Pondicherry. There, if there is a bill has to be challenged as invalid, otherwise it will be valid. Because a notaire is supposed to be going into title to the property, and then he draws up a document, and then the document is presented and registered. Then it is an assurance of title to the property itself. Now I'm going to be talking only on this, and therefore I started with that. Our understanding through the Indian Registration Act was completely different. The Anglo-Saxon jurisprudence of what India follows is completely different from what the continent does. So what was till probably it was only in the late 60s, the 69 or something is when the Registration Act was made applicable in Pondicherry. Otherwise, all transactions were drawn up by notaires. They were taken as valid transactions and affirmation of title to the property itself. No matter that a person is merely registering the document, and the person who gets it has a full title to the property, and anyone who wants to challenge it should have gone to an independent suit and then done it. Now I'll run you through certain slides, and Prakash tells me that I can probably talk to you for 40-45 minutes, and then leave the rest of the minutes for questions. Or probably I'll do even a smaller job. Or what I'm going to be doing is to share a screen with you that which will serve registering the document under the Registration Act. I thought I'll run you through a presentation content outlay of what this can be. I'll first explain what I'm not going to be doing at all. I will not do anything about what documents require registration. Section 17, I'm not dealing. And because that is very important for a trial lawyer's point of view. What document is required to be registered? What if it is unregistered? To what is the extent of admissibility of such a document? Very important areas. Section 17, 18, 49. And they are very important key provisions. But by themselves, they will take a huge time. I thought, therefore, I'll refer to certain other aspects. And then if you're looking at powers and duties of a registrar, it is available in Chapter 11. But the interesting point of how even our court looked into it, one of the judgments from the from our court was a brilliant exposition of law, who is now also in the Supreme Court. He had a very interesting narration about how when you want to read the powers of the registrar, you'll have to go elsewhere, not merely with the powers of the registrar elsewhere. So therefore, the statutory provisions that set down the hierarchy of officers, what are the documents which are under the control, and what is the presentation and registration. The presentation and registration which comes before Chapter 11, Part 11, contains a lot of important things of what the registrar must do when somebody goes and presents himself with the document. So therefore, those provisions, though they do not come under Chapter 11, I'm taking them through a decision of our court, of Justice Ram Subramanian, who is now in the Supreme Court, takes that position in a big, and therefore I thought those are the initial provisions which we'll also see. When the registrar takes up, what is the nature of inquiry which he conducts? What does he do? How does he assure to himself that the person who has come there knows what is written about it? Or what is the extent of inquiry? What type of inquiry? What is the nature of adjudication that he makes? And the issue of title and cancellation, because that is what is the key areas of contest where the law is not settled down. It's a kind of a flux. It keeps happening. There are any number of cases from various states, there have been various views. So for us to know, apart from merely the sections, what has been the trend of law, how the wind has been blowing is what we'll see. And the challenge provisions, for sure. We are talking about the registrar's powers being challenged elsewhere. What are the areas of challenge? Meaning no disrespect to lawyers who practice on the writ jurisdiction only. I was a person drawn from a Mofussil place. I have seen the provisions, anything, I'll have to bring it within a civil suit. That is the way I will look at it. But then if you come to the High Court, anything will go for a writ petition. So therefore, you have a whole lot of case law on that. Whether you can come to writ petition directly to a challenge. When can you challenge an order passed by the registrar or sub-registrar? What are the internal mechanisms available? Do we have a full answer in that through the Act itself? Or will every decision of a registrar to register or not register, are they seen as mere administrative actions and judicial actions, quasi-judicial actions? Now, what will be the level of interference which will be possible? They used to say, some of the lawyers would say, many of the original side rules went for a toss only because of writ side lawyers. Because any document will be pushed, they'll just give it across the table to the judge and he has to take it. But then you had the original side rules, which were very elaborate, which had a lot of things to say about when it can be received and things, but then it has all gone for a spin. So the same way, probably, so much of writ petitions coming without really exhausting the provisions. Therefore, I thought we'll run through quickly the statutory provisions first. I'll take you in less than 5 minutes time to see where it goes to the other subjects as well. Yeah, the statutory provisions are, look from down up. The sub-registrar, you see, is the person who has a kind of original jurisdiction. It's like the subordinate judge, the munsif, is like that. You don't go to the registrar for registration. A subordinate registrar is the person, sub-registrar is the registrar. You have also offices like that. There will be only in several places, only sub-districts and sub-registrars. The registrar will not be there. It's there only in one district, but probably there will be only one district registrar. There could be additional registrar. But then like the court of first instance, the place where you go for registration of a document is the sub-registrar. So that is where all documents are there. You will see a lot of activities only in sub-registrar's office, more than the district registrar's office or the IG of registration. Above him is the district registrar. District registrar has also some original powers. There could be instances where in a place you don't have a district registrar appointed, a sub-registrar himself can be appointed as a registrar, holding additional charge as it were. What is the effect of such an office? We have a decision from our court. We know the court has examined that. That's therefore important to see. Then you have the district registrar has power of appeal. Any refusal of registration, which a sub-registrar does, otherwise for a reason than a denial of execution. There could be so many other reasons. The property is not properly described. All the persons are not there who must sign, they're not there. Any of the circular has not been properly adhered to. Any of those reasons which will go for refusal of registration, all the peripheral issues, you have a right of appeal. And the section, there is a provision for an appeal. And then matters where a registrar, a sub-registrar denies registration and refuses to register, then the refusal of registration can be challenged not by an appeal, but by a petition. That's rather unusual. You don't have, I'm not aware of any legislation where you challenge something through a petition, where a challenge is made by an officer, of an officer's order of a refusal to register. The law contemplates under section 73 a provision for your original petition to be filed. And now here was also an appeal. Appeal powers are with reference to powers where I said there could be refusal for reasons otherwise than for denial of execution. You have a provision for an appeal. Then you have a supervisory jurisdiction, like what the High Court has under 227. The registrar also has a supervisory jurisdiction, the same way as the IG of registration supervisory jurisdiction to both the registrar and the sub-registrar. So that hierarchy is clearly made, and any complaint against a sub-registrar for so many other things, because anyone has innumerable complaints always. So complaints you will have to the registrar, we will see. He'll be the person who is entitled. And then the idea of registration power, the rule-making power, so many things of what happens. It doesn't go to the registration department, the Ministry of Revenue, probably, which has some control. The whole lot of rules and things are made. The circulars, effective circulars are made only through the idea of registration. Therefore, the rule-making power of what section 69 talks about, 1G, it's best put to use only by the idea of registration. You have a circular for life certificate. Not every state has. We have that. You know, a life certificate is when there is a power of attorney that the man is still alive. The same way as a pension. Now I started receiving pension. I need to certify myself I'm alive. So now and then, these kind of things would require also. This is a hierarchy. This books and registers, I thought you should know, only because it's as lawyers we must employ now and then languages in court which are appropriate. You must say when there is a document which is required to be registered under section 17, where there is a mandate for registration, then all non-testamentary instruments. Non-testamentary is when section 17 is immediately attracted. Testament is will. All non-testamentary instruments of where you have under section 17 and under 18 as well, they will all be entered in book 1. That there is a registration taking place, it is in book 1. So what you should be seeing is it in book 1? When somebody says you should be immediately able to contact, it comes under section 51. What are all the various books? Because if there is a fraud, if there is anything which impinges on the genuineness of the document, you have a power to inspect documents. You should know what document you are going to be inspecting. It's a remunerative practice for young lawyers when you have your senior drafting document. Never stop an opportunity to go to the registrar's office. It's not like going to the police station. It's not to be seen that way. That's a place where, like the bank, there's a lot of money happening. So therefore, registrar's office to know what these books contain, because you have a right to carry inspection. Personal inspection is possible. Only for wills, the registrar alone can inspect. Otherwise, you have a right to go into the record room. You make the fee. You can ask for the registers. I have seen those registers. I pull them out and see what these are. There will be somebody who will be standing by you. And if there is a document which is not registered and it is refused, the registrar must enter it somewhere. Where will he enter? Book 2. So therefore, you should be asking, the document is not registered, let me see what is book 2. Sir, what is contained there in book 2? That kind of expressions which should be familiar with. And that must contain a refusal to register must be there. And register of wills. Wills, it's entered in a book 3, where you don't have a public access. And there's also an interesting judgment. Rajesh Khanna, you know, famous actor of our times, probably some of the young lawyers may not have seen. But if it's fashion, it's Rajesh Khanna. The way he sings, the way he puts his head and then nods his head, they're all some at some point of time great fun for us. And Rajesh Khanna left behind a will, and so was a claim made by a person claiming to be his wife. So we know probably the only other wife who was, it was Bobby, actress, was a popular person. But then when a will was made and somebody was asking for a copy, whether it could be put out or not, what is the, can somebody have access to what the will contained? There is now a prohibition, a kind of an order. Now the will recitals will not be now put out. There is a contest and it cannot come, is what the Bombay High Court has said. So therefore, to know that will cannot be made available to everyone, it's not a public document, a registered copy. The access only can be had to those persons who will be heirs but for the will, or persons in the same thing as a caveatable interest, or what we say. That is what would also determine who can have access to the will. And there is also a miscellaneous register. This contains all documents which are mentioned in section 18D2F. It's the same thing. These are again 18. The 18 itself talks about the non-mandatory registration part of instruments, say an adoption deed, for instance. So there can be a proof of adoption otherwise than through registration, or there can be a registration itself taking place through adoption itself taking place through registration. Same way as marriages, there can be a proof of marriage by registration of a marriage which had already taken place. There can be a marriage taking place through registration. The same way about adoption. So it would come under the miscellaneous register. Marriage register would come under miscellaneous register. There are things like that. And there is also one thing which is unusual is I can make a will and then deposit it with the registrar, and that can be kept as a secret. And I have only the person who makes the will is the only person who can claim access to it and then take it and probably do something about it. He can destroy it, because manner of revocation of the will under Indian Succession Act, even if you tear the pages, that amounts to revocation. That is provided there under that. So those are the books of registers which you just need to know. What is the book you have an access to, you must know. And then powers, like I said, though you see it is coming under another chapter, chapter 11, the presentation part of it comes early. And the document is to be registered within 4 months. These are very fundamental things which everyone knows. I just thought that will be a completion for it when we come to powers. It should be normally within 4 months. If it is to be immediately done, or if there will be beyond that 4 months, some leeway is given, some discretion is given to the registrar. He has a right to collect some fine, which can be as high as up to 8 times the stamp duty which is payable. Then who can present it? A lawyer doesn't have a right to present. The power of attorney, or what he needs to have a power of attorney, he is the person. Presenting is a manner of, it's just not accompanying a person and then giving it. We understand it in a very technical sense. A presentation is a person who will be recorded as having presented the document. He is a person who is entitled to hold custody of the document. Who will be that person? If it's a sale deed, purchaser, gift deed, a donee could be there, or even in respect of a gift, the donor himself may present the document. So who can present? The law talks about who can present. The person who are parties to the document, 1. 2, it could be a representative. What do we understand by representative? Persons of civil law understand as a person who may have not necessarily heir at law. He could be an interloper. But then representative, what this act contemplates, would be a situation where a person executes the document. He has died, and it's executed, and within a short time you have to register it. That man has died. What will the purchaser do? He has a right to ask the representative of that person. Could be one of the legal heirs, where there are several persons. Not all persons are required to present. Any one of them is sufficient. That is what it says. Then there is also something under we need to know. There is some difference. Not really that comes under section 17. Tamil Nadu has legislation which requires the power of attorney to be registered if it involves property whose value is more than 100 rupees. But not all states have. This is a later introduction. But then we must know that there is, when is a power of attorney required to be registered? Power of attorney is not normally required to be registered, but in Tamil Nadu it is required to be registered. But then it is bound to be registered in a situation where a person who admits execution is a person different from the person who executes. That is what the registrar must see. Let's say, supposing I execute a sale deed. Then I'm not able to go to the registrar and then present it. Then I'm asking my brother to go, you'll have to present it, I'm going away. I can't now put that person, even if I make a power of attorney, to go and do that. Because the person who executes, that is who has signed the document, if he is not the person who is going to present it and somebody else is going to present, then that power of attorney would require registration. The difference would be, supposing the brother is himself the power of attorney for me, and the sale deed is made in the name of my brother as a power of attorney for me. In such a situation, that power of attorney, when he goes for a presentation, it does not require registration. rather curious, but that is a kind of a difference. With the registrar must see, and we have Justice Sundaresh judgment, which I'll refer to. What would happen if the registrar doesn't see what is contained there? Because this you don't have under Chapter 11, it comes under the presentation formalities. If registrar can be asked to come home, he can, there is a new requirement there in our law, which would require the photographs of the purchaser, the vendor and the purchaser, both of them will have to be when we have a provision. The registrar can come. And there are exemptions, the same way as we say for commissions, where you say some persons need not be brought to court. They can be examined commission. What are we saying? Any person in infirmity, a person who has a handicap who can't come, who is ill, who is not able to come. Any of those situations of where a person's ability to come is in some way impaired, then law allows for an application to be given to the registrar to have the registrar come home. It's even in a situation where there is a marriage, registrars can be brought home. What is the infirmity at that time when we are talking about? And this is governed by different rules, but the infirmity anyway is man is preoccupied with better things. Be there by his wife's side. Why would he go to the registrar's office at that time? Though we say the registrar's office, you see newly married people coming there, but then registrar can be brought home for registration marriages. Normally they accommodate such a request. After all, the registrar can come and have good food also. So that is something incidental. And then there is one provision, the re-registration provision. This is the case law comes somewhere under re-registration. Supposing a document is registered by a person who does not have authority to do. A person claiming to be a power of attorney for me executes it, has a power of attorney which I have cancelled that was not disclosed. Then I have a right to re-register. If only a re-registration is to the same person, then a re-registration provision is applicable. This comes through a judgment. This is an old judgment of Allahabad. What would be the effect of a person who did not have a competency to go and register? And then the true person who is the competency, he comes to know about it. What should he do? There is no provision, is what the High Court at the time had said. Therefore, this legislation amendment was made for that. But this is a provision where if you want to look for cancellation of a document, if you're searching for cancellation, you will probably land under section 17. 17 talks about what are the documents which require to be registered. You'll find it there. But you won't have case law there. You'll have to go under 23A. For some reason, many persons, decisions, they have come under this. And re-registration, if only it is to the same person by somebody else, then it could be re-registration. But then if it is completely to another person, the document itself is required to be cancelled. Cancellation can come only by means of a suit. How can it come? What are the situations? We'll soon see what it is. So again, another important thing is a registrar cannot refuse registration because it is undervalued. Undervalue, you impound a document, keep it and require the money to be paid by him. Registrar can say, I can't register because you have not paid the adequate stamp duty, the value of the property is more. In which case, the powers come completely differently. Refusal does not take place. Just for you to have at the back of your mind what this would be, how this will be done. Yeah, the actions prior to registration, or what you will see quickly again. Enquiry under section 34. This enquiry is completely different from the enquiry which the courts undertake. A person will be asked, did you execute it? And the stage of admission, supposing the person comes there and says, I don't know, I have not received my consideration, sir. It says consideration is paid. Registrar can't hold his hand. He can only say the person has admits he executed. He says money has not come. You register money has not come and still register it. So therefore, the denial of what is essential is the moment a person who is supposed to have executed a sale deed, he comes there and says, and notice he doesn't, the purchaser goes and brings it. He is bound to secure the seller also to be present there. Seller doesn't go there. So what the registrar can do is he'll issue notice to him. And if he doesn't show up, no, he has not come, therefore I'll register. You can't do like that. It will be treated as refusal to register if a person does not show up. A person who executes the document must admit the document by arriving there. If he doesn't choose to go there, it amounts to refusal. So, unlike a civil suit where a person remains ex parte, you can have a decree obtained by an evidence given. No, it is not like that here. If the man who has executed a sale deed or lease deed or a gift deed or any of the instruments which are required to be registered in section 17, it doesn't show up. It only means, yes, denied execution. There are also instances where a person could be saying that I thought it was a sale deed is written it as though it's a gift deed. If you couch it as though it was some fraud or coercion made, the registrar can't say prevent registration. He has to only say, you will go to court, I'm now registering it, he'll say. But there is a principle which I'm sure your seniors will explain if there are junior lawyers there watching this, where a non-est factum is a principle where I didn't know that this was the document. My mind did not follow this. I believed it to be something. I thought it was mortgage. It turns out to be a sale deed. All those situations where you do not even know what the document is. That's a non-est factum. And the interesting judgments are there. You have Justice M. Srinivasan who explains the principle non-est factum in a very interesting way. I'm sure you'll be able to land that to say what it is. So non-est factum is completely different. When it can be refused, it comes under the registrar will also, as soon as the document is presented, what is the nature of document will be necessary, because there could be instances where release, I make a release in favor of say Krishnan, and that release, unless the releasee and the releaser, they had been both joint owners or they had fractional shares of the property, 3/4, 1/4, anything like that, you can release it in favor of another. There is a lesser stamp duty for that. Some people even make release deeds who are, the releasee will be a person who would not have been an owner already or a co-owner. Such a kind of a person, if he takes a release, it's actually only a conveyance and not a release. You won't be able to, by merely adopting a nomenclature of a release, you won't be able to do what is otherwise prohibited. No, registrar must decide that. What is the nature of document? If he denies registration, now this is, you have written like a release, it's not a release, it's actually a conveyance, therefore I want stamp papers to be done differently. I already told you, mere inadequate stamp will not be a ground for refusal. But where the nature of document itself is turned out to be something different, he can say, no, I'm not accepting this. It's possible for him to do that. Some people use some expressions which are not correct. Pending pottanga. Pending potter, there is nothing like that. Either he says it cannot be refused in hand, it cannot be registered and given to you, or he enters it in book 2 and says why I will not register it. All that will be possible. And if it is otherwise than for denial of execution, where an appeal will be possible under section 72. So that makes a difference for us. And the nature of document also, the registrar has a power to see. The nature of inquiry which is to be conducted, this is what I said, Justice Sundaresh has decided on this, and asset construction versus IG of registration 2016. This is a case about sale deed which is executed by a person claiming himself to be a power of attorney. The power of attorney specifically says that I did not have the power, I am not authorizing you to sell the property. You will negotiate for sale, you will show the property to the person, everything. But before, if it is to be registered, my special permission has to be given. That is how the power of attorney was. 2 months later, another power of attorney is made where that power is also given. That is not registered. The first document was registered. When a sale deed was made, the sale deed was made only with reference to the registered power of attorney, which did not contain a power to sell, to admit registration, which came subsequently. And a writ petition was filed. Among other things, the challenge was writ was completely not maintainable. The sale deed has been affected. And if you're going to be saying that this sale is not valid, file is independent suit. There is also a civil suit which is pending. Therefore, you can't come by means of writ petition. I said our lawyers in the High Court like to try all rights under the writ petition. And therefore, you have a judge. This again, I can tell you, I can say things which others probably will not like to say. If you have been a judge from being a lawyer, you adopt some liberal approaches to jurisdiction. Where you come from the ranks, you still get worried a lot. So therefore, Justice Sundaresh, I would like to see, has a liberal construction of things. He says, now why need to go to court? Merely because he's filed a statement or he's going to contest, that doesn't make anything. This is fine. There is a power which the registrar did not have. He is bound to see what the power contained. Already said, as soon as a document is presented, he has to see whether he's a party, he's a representative, he's a power of attorney. If he is a power of attorney, does that power grant the power to send? But does it grant the power to admit registration? All that is there. If he doesn't do that, the sale will be invalid, void. It does not require to be now challenged by means of a suit. If it comes by a writ petition, there is nothing wrong. That is what is judgment. A liberal construction of what you need to know, and therefore I took it for you. 2016 law. Refusal for registration could be, reasons for refusal will be entered in book 2. It has to be in book 2, refusal, it has to be there. Therefore, why did he refuse? You have a right to see that. That will determine whether you go by means of an appeal under section 72 to the registrar, or he refuses for denial of execution. You will not file an appeal. You will file an application in section 73. They make a difference that has been brought through decisions of our court, and therefore that we will know. There could be also a refusal for registration for alteration of something that does not come under denial of execution. It comes under refusal to register for reasons other than for denial of registration, against which you have right of appeal. That alteration was done with this consent. All those kind of inquiries will still be made before the registering officer. And then I already explained to non-est factum. And on refusal, the remedy is to apply for registration in section 73. That's right. It's not an appeal. Where a refusal is done by the sub-registrar, you go to the registrar, then you'll do it under section 73 by means of an application. Justice Ram Subramaniam explains in a case where the sub-registrar is given holding additional charge as a registrar, and he refuses registration. Normally 73 talks about only his thing. If a person refuses registration, you have to only put it up elsewhere. But registrar, because as a sub-registrar works as a registrar, then he immediately assumes the power under section 73. You don't need to go with an obligation. The presentation itself may be treated as an obligation, is what our court says. It's rather an expansive understanding of law, and that you have it through the judgment of the court. Actions post-registration is, what do we do? We'll soon see what those instances could be. This document is duties and powers. This is what is part 11. I'll assure you in another 10 minutes I'll close. Immediately on registration, duty to record time and all those things. You have under this, these are all clerical activities, you will notice. That's nothing of extraordinary things. But these are important for you to know that when a document is brought for a challenge, you should be able to see every one of these things. In which book is it entered? And then what has he done? Has every one of those steps been gone through correctly? Is everything under 22, 23 presentation, has it gone through correctly? The 32, 33, 34, has it gone through correctly? And then 52, 53, 54, these are all entries to be made, numbered consecutively. They are all important, because when you are talking about some interpolations, when we are talking about some kind of things, in one of these things, there will be surely, if there is a document which is suspect, but in some of these procedures, you would lead a trail. At any time, if there is a theft or something, and a person who is a thief leaves a trail, they say, the same way, in any transaction which is fraudulent, you can find that there is something left off somewhere. Entries to be numbered consecutively. You can see whether it is properly done. To be indexed, does the index contain all those details? The document, how many pages are there? Are they contained or not? You have access to every one of these things. The numbering, and the indexing, and the way the parties' names should be entered, copies of entries to be dispatched to registrar. Persons in the criminal law, when we are talking about fraud in a complaint, FIR, when did it reach? Did it go through an express messenger? When was the party brought before? When was the accused brought before the magistrate? All those small details, you split an event into small sub-events and test everything. The same way you should test everything. Whether it went to the registrar after these entries, did it go to the registrar or not? The sub-registrar who wants to make a quick buck and then wants to assist some party, you may have missed out something in all these things. You should therefore be seeing they have relevance to see whether the trail is complete. And power to administer oath he has. Signatures of executants to persons admitting registration and making endorsement. Signature, what did he do? Did he endorse it there? Who identifies him? He has also power to identify. On the second page, you will find what is done before the registrar, what is all required to be done, are set through each one of the sections. And the last three issues are very important. There is a record of registration. That is, as soon as the document is done, he has to enter it there in a book. There's a record of registration. And issue a certificate of registration that comes independently. You may have seen, along with the registered instrument, there could be just a small piece of paper. He issues a certificate. This is what completes a transaction. He makes a certificate of registration, and all that will be copied to the margin in book one. Book one, I said, all of this non-testamentary instruments are to be entered in book one. They'll all be there. After registration, then anyone can go and ask for inspection of the supply certificate copies. That it's not possible, sir. Registrar will not give. Nobody can say like that. You have a power, you have a right to secure these details. And you can make search of entries in book 3 and book 4 shall be done only by the registrar. But book 1, book 2, you have a right to ask. I have a right, like we do in our original sections, don't we? We go there to original section, why is the document returned? Why is everything? You have a right to go there and see. But it could be costly. But here you must know that there is a section which gives you that power. So therefore, don't feel offended off that you have a right to secure that is what we need to know. And then registration of documents by means of, this is unfortunately not given in a given effect in a very big way. This is Tamil Nadu Act 50 of 2000. I wrote in the previous edition, Mullah, in 2012, with technology having come the way it has, there should be no doubt whether a person arrived at the place or not, whether he understood what the document contained or not. Everything is there. You have CC cameras. The whole thing must be digitized. I even wrote to the Ministry of Law and said, no, digitize the whole process of registration. Tamil Nadu was amongst the first states to go on record to say that the whole process of registration will be recorded and it will be given along with the document of registration in a pen drive. I'm not too sure whether it has put in practice everywhere. If only it happens, all the questions, the challenges to a document, he didn't know what the document was, the registrar did not explain to him properly. We rely on 114 presumptions, but if only all these things, if you use technology, like technology in our COVID times has suddenly brought us together. We are able to sit in our respective houses and then we talk to each other. That I could be talking to so many of you, that I could be seeing so many of you, such an excitement. Same way it should be possible for us to use the technology for better purpose. See, our policymakers, they should be made merely not to give some statement somewhere, that they all make it possible. We should, through associations, we should be able to prevail on the government to say that the entire process of registration is made available, because Part 11A looks to that as something which should be possible. It is not happening in a big way, but we should make it work. And then appeal provisions, I said appeal against a refusal other than denial. There is an appeal. If it is the denial of execution where a person says he does not come there to that place, it's an application which has to be filed and not a denial. It will not be by means of an appeal. And then what is the nature of inquiry which is to be seen, and that also in the application, the registrar also says, no, this document cannot be registered. Then a person who is aggrieved by that has a statutory suit, goes under section 77, and that has to be done within a period of 30 days. Limitation Act does not apply. You'll have to come within the time. Section 14 probably could be very difficult to be invoked where there is a provision where the Act specifies a particular time within which it has to be done. These are, by and large, the whole lot of provisions relating to the powers. Now, these are the area. What I would like to show to you now is what are prevalent, which keep coming. These are the decisions which Apoobah Patel versus IG of registration 2012 6 MLJ 248 is an interesting judgment. This is, I only take this occasion to be showcasing some of those decisions, and I expect you to read them. What did Kannan do? Kannan showed to me some law which I had to read. I'm not going to be reading to you. Apoobah Patel is an interesting judgment, Justice Ram Subramaniam. He writes in a way, makes enquiry before the registrar and enquiry elsewhere before a court are different types of enquiry. He tries to make out a distinction, same way as he speaks from public platform as to how this word is different from that, as a typical political approach, what goes through this judgment. And then cancellation. In Delhi, there was a provision. Supposing a document is brought and registered, and the person did not have a right to the property, he registered. And then a true owner comes to know. Then he can have a cancellation done. So they made a circular saying that the registrar can, for reasons to be recorded, cancel the registration if it has been brought about by vitiating circumstances, was a circular. This was challenged in Delhi in 2018, Delhi 4688. This is this Delhi decision. Probably you have, yeah, there is. This is Manupatra citation is what I have. I am not too sure, but this ruling is very important. That a power to cancel, even for a vitiating circumstance, registrar does not. And if there is a circular which gives him that power, that circular is bound to be interfered with, and it can be quashed. And they quashed the circular. That is Arun's foundation as government of NCT. Where a party unilaterally cancels the document. I make a document, and then a sale deed is done later. I had executed a sale deed for such and such a price. He had not paid the consideration to me. There had been a failure of consideration. Therefore, I cancelled the document. Rattu Patram, Kraya Rattu Patram. Registrar does not have a power, but they'll collect the money. They get the revenue. They'll do it. Never advise a party to cancel a document. A cancellation takes place only through a suit to cancel a document. Or you can, in defense, say that this is vitiated and it is not valid. After all, fraud can be pleaded in defense. You don't need to go to court. As a defendant, you will be stronger without any bar of limitation. But then a cancellation document, unless it is bilateral, both parties come in, but then it can't be done otherwise than by court. And the cancellation through writ petition also, whether it is possible. In Tota Gangalakshmi in 2010-15 SCC 207, they said cancellation power will not do unless it's a suit brought through a writ petition, which will not do. I already showed you a decision of Justice Sundaresh, where he cancels the document. He cancels the document saying that this is a registrar registers the document and the executant claims to be a power of attorney. That power of attorney, if only he had seen the power of attorney, the power to register is not granted. Therefore, this is hopeless, and therefore I set aside. It was done in writ petition, but the point is still there in the Supreme Court. All those decisions, Justice Sundaresh has also looked into it, but he was able to easily distinguish. Normally, cancellation will not be done in writ proceedings unless you have something so serious. Because when we talk about 226 powers, there is nothing. It's a constitutional power. and you can't view it very narrowly. It's always possible for you to throw it and see where is the justice. And in Satyapal Anand was the state of MP. It went on with a big fanfare, whether a court has a power to accept a situation of any one party. What happens if the registrar acts on the will of one person and cancels the document? Can it be challenged? Cancellation powers of the registrar, will it be valid or not? There were two divergent views of Justice Gopal Gowda and Deepak Mishra. And therefore, it was referred to a third member. And it went in this Satyapal Anand was the state of MP. Unfortunately, it decided no law. It went back to the registrar to say he has to examine again. So an occasion when it arose, to what extent power of cancellation is available, it was not very clearly seen. Now I see various states, our Madras High Court itself has said the power of cancellation not have. That was decided in PAG Kumaran versus Inspector General of Registration, Santhom. And then you have Sikkim, you have Delhi, you have Karnataka. All these states saying power of cancellation by the registrar himself does not arise at the instance of one party. Another area which keeps coming before court where we are confronted again and again are problems are state amendments. With this will conclude. The issues of title. Several states had new approaches. They said, what happens if trust property is sold? What happens if religious institution property is sold? What happens if the government property is sold? So we should stop it. So Rajasthan and Tamil Nadu had a law saying that any transaction which is against public policy, it will not be registered. And they gave the power to the government to notify what will be against public policy. Rajasthan, from the Rajasthan, it went to Supreme Court to say you can't have that kind of power to be given to the executive to declare what is against public policy, because all students of law will know it's unruly horse. Public policy, what it is very difficult to define. So therefore, to leave it to the executive to decide that will be wrong was the Supreme Court judgment. Later, our Madras Court also decided that. But then what they did was, you had a similar provision, public policy, a sale against public policy, 22A. All across India, you had AP, Bihar, Karnataka, Maharashtra, Tamil Nadu, West Bengal. All those courts, after the Supreme Court judgment from Rajasthan, every court said that 22A public policy goes. Now we have a different altered public policy. Why give it to the state to say, even in the legislation, I will say these are all wrong. These kind of transaction, property relating to government cannot be sold. It will be against public policy. Many states have. But there was a Andhra Pradesh judge who did extraordinary. The Radhakrishnan Naidu versus AP, that is 2015 4ALT1. It's a wonderful judgment to read, and therefore I kept it there. It's a reasoning is exciting reasoning he has given. He says now registrar, he was unconventional in this approach, and he was unrelenting in his way of allowing for the registrar to decide whether a person has title or not. And a person who has title to say he shouldn't have registered, therefore cancel it. He said nothing doing. Even if it's a government property, you will register. If it will be registered, what will the registrar do later? He will then inform the government, your property is sought to be registered, I have registered it. Now look at these details. So he gave a kind of a new additional burden for registrars. Therefore, this Radhakrishnan Naidu's case is a case where you can't prevent registration, even when other courts do that, even when the legislation itself has in its principal provisions, what are the grounds when document cannot be registered. But even such a thing, register, inform the person, register, inform the trust, register, inform the religious institution, your property has been, they will do what is necessary, is what is stated. So these trends are some of the decisions which I thought come about in the manner of how the properties are dealt with and where there could be problems concerning things. So I concluded, I kept assuring you I'm going to close it. I didn't do that. But then for sake of completion, I'm sure in our little time that we have, whatever questions arising from this or anything relating to registration. That should be fair. A lot of questions I see, I can probably take it at random and you can probably Om Prakash can read to me the questions of where I will respond, or if you permit me, I will.
Yes, I'll do that, sir. I'll take you through the questions. And anything somebody has raised a hand also, we will also take that, sir.
Okay.
It was wonderful hearing you, sir. Very nice, informative, and a fast-packed session, which gave you a lot of insights into the small niceties. One thing before we go into the question, I was just looking at one area we normally say that this compulsory registration, which actually you touched upon, that a person executes the document, but he doesn't come forward for registration. Therefore, you pointed out an application has to be given to the registrar. That area which I have seen is that it takes a kind of a civil court proceedings, because I have seen cases where these applications are given, registrar issues notice, he calls for, takes evidence, cross-examination, then against which an appeal to the district registrar, then as you said under section 77, compulsory. Probably if you can just take 2 or 3 minutes, point out that flow of things alone.
Sure. Compulsory registration takes place when the person who executes the document does not show up at the registrar's office. A typical situation is when the father executes the sale deed, and then the son says, "Why did you do that?" He said, "No, this is my property." There is a problem between father and son. Then son is able to prevail on the father. You can't go to the registrar's office to admit it. So the purchaser has the document, he has paid the money, he has purchased the stamps, everything is there, he goes there. And the executant does not come. The moment the document is not admitted before the registrar has to merely enter in book 2. I can't now register. This constitutes a refusal to register, surprisingly. Then it can only send it to the registrar. Justice Ram Subramanian's judgment was a case where the registrar was the person, sub-registrar was acting as a registrar. So therefore, does he send it to some IG of registration, or what is the kind of inquiry which he will hold? What is the nature of inquiry? Now, the document is given to through an application, it is given to the registrar. Registrar will issue out a summons, and he has to come and say, at that time, the action in defense by the person who has executed shall be that I did not know, it was non-est factum. I didn't know I was executing a sale deed at all. He took me saying that there is going to be a mortgage. He has taken a sale deed. Or I have not received the consideration. He said he'll pay me consideration. He did not know. This is no good. Only the registrar at that time will see whether this man has executed it. Executed understanding what the document was, not about all the recitals that you're supposed to know, because we have another case law from our code, expressions which are felicitous by Justice M.M. Ismail, where it says a person of full age and understanding having subscribed a signature to a document cannot be heard to say that the document, he does not know what the document contains. These are expressions. So therefore, it will be no good for a person to be saying, it is, I didn't know what it contained, I merely put my signature. That inquiry of what happens after a compulsory, that is, the document is compulsorily registered, or you don't show up at all. Your notice is sent, you don't come even then. Then at that time, like ex parte proceeding, I sent notice, he did not come. So therefore, I take evidence from the person. This man came and executed the document, and then I execute. Then normally in all documents, you will have the vendor signing there and admitting registration. This can happen only if there is an execution in some sense, only at the time of registration has not come. It can't happen in a situation where a document is made, signature is not there. I said, I'll come to the registrar's office. I don't go to the registrar's office. It gives you no scope for a compulsory registration. If only I've subscribed signature to a document, I still don't show to admit registration before the registrar, then the document is compulsorily registered with the registrar saying this man does not come, or having come is not prepared to sign the document. I compulsorily register. The same way as in suit for special performance, the court itself can register the document if the person does not come in execution. Does he not? The same thing. It's another kind of a compulsory execution. So a compulsory registration is like a suit. If you've conducted, any one of you, if there has been an occasion, persons who are trial lawyers, it will be typically like a court. The registrar also has that red cloth and things. It's like a court. The registrar's court is like a typical court proceeding. So the inquiry of what is contemplated is like a court proceeding, and compulsory registration is therefore one quasi-judicial function which he performs. And therefore, look at that, how the law provides. Supposing that person agreed as a right to go under section 77. 77 is a statutory suit. You don't go by means of a writ petition or bring a challenge. Against that order, you don't go to IG of registration. You come by a statutory suit in section 77. That decision of what was taken, failing to admit the document or refusing to register the document, they all give rise to a statutory suit under section 77. These are some of the additional things of what probably I didn't tell you in any greater length.
Thank you very much, sir. Sir, I'll just take through a few questions. Advocate T.R. Sendil Kumar has raised a query saying that a family partition was registered, leaving behind one property since no sale deed received from CITCO. After 4 years, sale deed is registered. Can a supplement partition deed be done for that?
Perfect. Any document, normally a partial partition does not take place. If only you ask for a partition in court, all the properties are required to be brought for partition. You leave out some property, there must be a reason why it is left. If you say that, you can leave out and do. Same way about registration of partition. Several items of properties, one item of property at that time, CITCO, that had been merely a license originally, comes through registered instrument, or a license period is over after so many years. After that, a sale deed is made. At that time, they want to partition the property. A right to secure a sale deed later, which is an equitable right, can be brought later. And therefore, a subsequent partition to be brought about subsequently. You're going to be paying more stamp duty at that time. That is the reason. So that's perfectly tenable, Sendil Kumar. It should be possible.
And Advocate Sudhakar has raised a query saying that we find there are many circulars being issued by the registration department, IG registration. If the circular exceeds the scope under the Act, his question is precisely, the circular exceeds the Registration Act, would it be valid?
Obviously, you have an answer in your own question. And so therefore, if it exceeds what the power is, and now a circular in IG registration is what is this life certificate. The life certificate does not contain there in any act. The Registration Act does not provide that. A power of attorney to say that the principal still is alive and a certificate to be issued, it has come through a circular actually. And that circular is what is, not every state has it. Tamil Nadu has it. Because we suspect that persons who are dead are given power of attorney, or after death somebody is presenting. I don't know what has been the experience. Lawyers will know better what has experienced. It's all experience-driven circular, and it is valid. It has been because you have under section 69 a power to frame rules, and I already told you, IG of registration has substantial powers to govern how things have to be done. And in Kerala, the IG's what documents can be cancelled. Now, there could be typically a situation. Now, there are two circulars we can say. One circular from Delhi which said the registrar is, sub-registrar is required to see that the man who executes the document is competent to execute. All his sale deeds were proper. You are bound to see that. I told you, under the continental jurisprudence, the sale deed will not be written by all types of persons. Notaire is a person who must attest to the title to the property. And once the registration is done, everything is over. Here, all our high courts, even the judgment of what I referred to from Justice Ram Subramaniam, is this case says, no question of title, registrar will just register. Now, when a circular came in Delhi saying that he has to see whether the man has got title, it can be cancelled if there are anything which he thinks is suspicious, then the circular was quashed by the by the High Court in Delhi. And so therefore, circular has to conform to law. Whether it is merely regulatory, which is not in conflict with law, will be a matter of a substantial question which is raised and decided in a particular case. So, what is possible through a life certificate? If somebody in another court, supposing in Sikkim, they decide life certificate is not contemplated at all, it is beyond law. Somebody can reason out like that, but then you can say, after all, you want to ensure that a power of attorney can remain in force only during the lifetime of a person. So a manner of attesting to a person's lifetime, whether the person is live or not, is fair enough. It is done also in other things like a grant of pension. A similar situation, similar thing like that is always good to make for good transactions. Somebody could be saying. So circulars have to conform to law. And there are large number of circulars which have the effect of law. Practitioners of tax law will know to what extent circulars govern the field. Jai Kumar is there, so he'll tell you a lot of examples, probably how circulars have a field of how they have a position of law, strength of law. Some they don't, some they have. Both of them exist.
Thank you, sir. Mr. K. Venkatesan has raised an issue. He says a Hindu marriage is not registered. But when applying for divorce, will it be a hindrance for filing the petition? Because some courts are insisting for registration certificate at the time of filing.
If a marriage is registered, yes, but we are not making compulsory registration yet. Some states have done. Haryana has made a compulsory registration. Justice Kaju, in a judgment in 2006, had stated that the whole of India, they must make a compulsory registration of marriages. It's essential that we register also. But then look at the Hindu Marriage Act. The marriage is completed, the conditions of marriage is completed, and we have mere declared, the Suyamariya, the form of marriage of what the Dravidian parties brought, was perhaps the first in 1967 when they said a mere declaration of intent is good. So I go there, I'm the leader of the party, I say, please, you say you are married to her, exchange garland, you pick up the garland, do something, the marriage is done. So therefore, where do we have a registration?
I think I completed the answer there. So therefore, marriage registration has to be made compulsory if it happens. But then some courts asking for the document is we'll have to only explain. In India, marriage registration is not compulsory in all states, and therefore it is not possible. The marriage was not registered. But wherever it is possible for us, if you have your relative, always suggest a post-registration of marriage. Persons going to a foreign country, getting the wife over, all this would require registration. So therefore, suggest registration at all times to parties. But if it's not registered, no big deal.
Thank you, sir. We have Advocate Anand Shivakumar raising a query saying, sub-registrar refused to register based on unregistered will. What is the law?
Now, the latest information of what I have is that wills, they may require compulsory registration. It is there is a move like that. There can be no unregistered will. But Section 17 talks about non-testamentary instruments which are required to be registered. And so, therefore, a registrar of all the decisions of what I was saying, the Madras court including, the latest law is the registrar cannot, even in the judgment which I was referring to of Justice Ram Subramanian in Apurva, he has said the registrar has no business to go on title. So, therefore, on an unregistered will for a registrar to refuse, what you do is take that refusal. Is not then you have a right of appeal to the registrar. So that appeal you will file under section 72, say that the registrar is refusing to register, he is acting on some unregistered will. He has no business to go into this issue, so please register. So therefore, there is your remedy is by means of an appeal to the registrar against that. That is the way. He has no power to refuse.
Thank you, sir. Deva Dakshan has raised an issue saying, trust property can be registered without court permission, or is court permission should be sought for before registration. And it is in the context of saying that there is a recovery certificate by DRT of a trust property. Can the DRT grant permission to register, to sell and register the property?
See, trust deed must provide for a power to sell. Supposing the trust deed does not make such provision, trust deed, even if it is registered, title will not pass. You must remember, trust normally involves two different kind of situations. One is a trust which is a public trust. Public trust is not governed by the Trust Act. The common mistake of many people have is Trust Act governs public trust also. Public trust is governed by Public Trust Act of 1920. And where there are religious institutions that has gone from the Public Trust Act by HRNC Act in respect of religious trust and endowments which are notified endowments. So religious, charitable and endowment act. That endowment is kattalai, as we say. It must be a notified kattalai. Otherwise, it will still be the Public Trust Act which will be there. And Public Trust Act itself has a provision where you can seek a permission to the district judge for sale, permission to sell. It will be possible for you to secure that permission. Under the Trust Act, there is again the trust when we know, is this a partial trust or a whole trust? It's a whole subject by itself. We can go on a full scale lecture, but I at least give you some lead where you must see. For instance, if it's a partial trust, it means it's a property where there is a charge of trust on that. Supposing I say you enjoy the property, you will give Naivedyam and things for a particular day in Masi month, Tamil month Masi to Kapalishwara, something like that. Then it is a charge on that property. The property is not trust property, it's a partial trust, which can always be sold, and that charge will attach itself to whomsoever it takes. If only the property is completely endowed in a trust, which is public trust, such as for public charity. Supposing something like that. It's a complete dedication. It is 100% fully dedicated. Then it cannot be sold. So permission could be obtained in a case where there is what they say as cypress or cypri, or there are so many ways they say, where the original trust, which is motivation, which made the person make a document, that trust is not any longer available. Supposing you talk about some kind of charity, in the those documents I have also seen. Those were all some times where they thought there was a Eda Brahman. You never know. People were only begging and making things. Now, that kind of a thing may not be there at that time. So you can see something which is more akin to that kind of a dedication you can do. So my answer to you is, first see whether it is a complete dedication or a partial dedication. If it's a complete dedication, power of sale does not happen. But a DRT may not fetter himself. He will sell the property and somebody can restrain the sale, he will do that. Because DRT does not assure any title to a purchaser. And the person who has taken if the bank has taken a security of a property which is a trust property, OB to the bank, they may lose the valid security, because it may not be a good security, sale will not be valid. Some members of the public could be challenging this whole transaction, saying that this trust, I'm a beneficiary under the trust, and therefore this can't be sold, could be an issue. So that's my answer to you.
Thank you, sir. Sir, in fact, you had said with a lot of passion about this inspection of records from the registrar office, and you had a point to the junior advocate saying that you have to exercise such right or such option whenever it is given in an office to go for a registrar office and go for inspection. That was a wonderful thing. In fact, most of the learning happens when you, learning with regard to this documentation happens only when we deal with this. So there had been some exchange of views by the participants that this search and inspection of the registrar office, whether it is still available after this digitalization.
Very much available. Very much available. You have a right to demand. You must go. See, that is why corruption takes place when we are not fully empowered. If you don't know what your powers are, you should be in a position to say, I would like to make a personal inspection myself. Encumbrance, that's why you will find in the encumbrance, the last two small lines in fine print is, the registration department does not, and it's also a rule 58 or something, the registration department does not assure full correctness of the entries. They may say there is an exclusion only because you have a right to search yourself. You have a right to call for the registers. You have a right to call for the books. Have a look at all that, because all that I said, when a registration takes place, the name, address, everything will have to be written in that book. And in the one In the must be written, the registration details must be there. At what time it was brought, the date must be there in the margin. The whole lot of detail must therefore, they are accessible for persons, and therefore you are entitled to ask for it. So you have a right. No changes have been made.
It is now different. We had the benefit of going through the files, books, everything. You have the index, everything. Now it is only a click at the button with the computer.
Correct. Correct. So, see, now so much of information is available in the registration department. For a module which I'm helping, I'm a part of a committee which is set up by the Supreme Court, where we are trying to see what are those areas where adjudication need not be there through court, and when can we merely be exercising a supervisory power to see whether some transactions have been done correctly or not. We are actually looking to automate full automation for registration of documents and proof of documents, where through artificial intelligence we'll be able to gather all the necessary data to ensure this is all speeded up, and the adequate controls are done through a process which will be transparent, which will make evident that every little detailing of what the section contemplates, it's all done. So therefore, that is the future to take place. That's why I said we need to be making demands adequately on the government. Having made a Part 11A, we are not fully bringing digitization in the registration department. That we must make.
Thank you, sir. Mr. Jitesh Kochar had raised an issue saying that an interim award in an arbitration attaching a property, does it require to be registered before the jurisdictional SRO?
No, any attachment itself does not require to be registered. It's a facilitative provision. So, be it of a court or arbitrator, attachment proceedings can be registered. It's a manner of saying that somebody knows about it. There is an interesting decision from Bombay sometime recently, where I've also referred to that everything cannot be there through registered merely because registration. This was done in Kusum Sharan versus Additional Member Board of Revenue. This decision is the Bombay. I'm making. Sorry, Sri Prakash Govindra Mahuja versus Ganesh Lohande. This is in 2016 from Bombay, where they said the practice of stopping a sale by issuing notice to the registrar and the registrar entering in the books, yes, somebody has objected, can it stop? The same way, it's the same thing of when you're talking about registration of an attachment. It does not really interdict a sale. The person who purchases the property purchases it subject to that attachment, that claim. That's all we must know. So therefore, don't believe through this that you effectively put a stop to the sale. It will not take place. It will not happen. So therefore, even a notice or even an entry by a registrar that there is an objection by this person, it cannot be sold. They said it will not be valid is what is in 2016 Bombay decision.
Thank you, sir. Sir, Mr. Mohan, N. Mohan has raised an issue saying there is a partition deed between two brothers registered duly. Post that, one of the person goes to the court seeking for cancellation of the deed or questioning the validity of the deed. In the meanwhile, the other person, and he has also obtained an injunction, communicated to the sub-registrar. In spite of it, the other person had executed a sale deed and the sale deed is registered. What will be the position of the registered sale?
Correct. Actually, these are interesting situations. There are several different views to it. There can be restraint against an individual. This is also governed by case law from selling a property. If the registrar registers the document, he commits no mistake, because a public authority cannot be prevented unless, because under the specifically fact when injunction can be refused, section 41, public authority cannot be restrained from doing its duty. They have a power to register. But then if it's registered, there is a decision from the Supreme Court, not now, it's in 2012, where they said that if there is a restraint of sale by a court and the sale is registered, the sale deed is invalid. There is a decision of the Supreme Court like that. So therefore, you are protected in some sense. If there is a court order, you are not going to be affected by that. But cancellation of a document, when you are making in any court, you'll have to show that it is cancelled for reasons which the law admits of, that it is vitiated by reasons, or he is not the owner of the property, the sale is not binding on you. That is the kind of thing which can happen.
Thank you, sir. Mr. Devananda Manikam has raised, what is the provision of law for registration of judgment and decree passed in suits relating to property?
You have simply no fetter at all. You can go and register it at any time. Not even the 4 months time is available to you. You can, I've come through the other thing. Are you able to see me?
Yes, sir. Yes.
Yeah. So therefore, registration of a sale deed, there are two things: where a suit for special performance is made, where a registration is made by the court. The section 17 contemplates situations where a person, personal attendance is not necessary. The law itself exempts it. But a sale deed, a judgment or a decree to be registered, it's optionally registerable, and therefore you can register it at any time. Even the limitation of time of 4 months' time does not apply, and you'll be able to register it at any time. So there is no prohibition against that. The registration of judgments, I don't think judgments are registered, decrees are registered. I think somebody has also answered for me, gives me a prompt. There is a provision there in the section. It says, yes, decrees can be registered. These are not compulsorily registerable, but they have the option. You have an option to do it under section 18. Yeah, is there anything else then?
Can we have a few more questions, and 3 of them are raised their hand, sir. I will only take your convenience of your time if it's.
Yeah, I'm eminently an unemployed person. Don't worry.
Sir, Mr. G. Anandaselvam advocate has raised a question saying whether after the death of the executor, the sub-registrar has power to compulsorily register the document executed by.
I understand, slightly modify the term. We don't say executor. Executor is normally in the sense of a person who is an executor under a will. We say executant. If the executant dies, the representative will be the person to whom notice will be sent normally if he does not show, because he would not have known the deceased had executed a document. The notice may come. He will be joined in such a thing. It will be taken as the person does not come. The proceeding under section 72 will take place. It's a process of compulsory registration which will take place. The inquiry will examine whether the deceased had signed. So some witness the purchaser will bring to say it was his father who executed it. Look at these documents. The son may say, I don't know about it. If the registrar comes to a conclusion, yes, the father had executed it, he has a power to direct a registration. He can either direct these persons as legal representative to sign there, or if they don't do, it will be compulsorily registered, marking their absence or their inability to or unwillingness to join. So that is the process. The executant, who are the persons who are entitled to present? The first is the parties. Second is the representative. The third is a power of attorney. That representative is a legal heir who will represent the estate of the person who is dead.
Thank you, sir. Mr. Prashant Rajagopal raises an issue. Nowadays, the sub-registrar insists on inspecting original title deeds without production of which they refuse to register the document based on a notification by registration. What will be your view on this?
Registrars are the IG registration. They all they do their own stuff. If you I had an occasion to see somebody was seeking my advice. It's about some lawyer who understood his understanding of Hindu Succession Act. He applied it also to Indian Succession Act. A man, an Indian Christian, he dies, leaving behind his mother and his daughter. So mother and daughter, therefore the grandmother and the granddaughter. So the man is in the intermediary. The one step more, the mother, the daughter. Under the Indian Succession Act, when the wife is also expired, the daughter is the only heir. But what the sub-registrar did was, he registered a document from the mother as though she was entitled to half share in the property. Now, the person who was seeking my advice was for the daughter. I said, no, daughter is the only person who is entitled. If she is willing to sell the property, please let her sell the property. When the sale deed was made and presented for registration, the sub-registrar said, no, I will refuse to register. because the mother has already sold. So I wanted an explanation. Don't try to do anything like that. It's against the act. So then it went to the IG of registration. IG passed an order that it is wrong. The previous registration couldn't have been registered. I direct the registration. But if you are affected by that registration, you go to independent suit. That's what he said. So registrars have problems. Several persons, amongst things, 22A, there is a law which says under 22A. I didn't read that. In the slide I had made it. If a document is dealt with any other person previously, then the document can be prevented from registration subsequently under 22A. So somebody, the registrar saying, show me the title deed, let me examine whether you have title to the property or not. But there are case laws enough to say that registrar has no business to go into issues of title. He has to simply register the document. He has to see whether the person is not a minor, not a lunatic. He is a person who is prepared to execute. If I go to execute your properties, the registrar is bound to register, because that assures a title of what the continental jurisprudence affords. It is not afforded in Indian law of registration. But there are exuberant orders, circulars and things, because they know that's a way of getting money also. So that's how there is nothing legally binding about it.
Mr. Saravanan I had raised a question. Can a rectification deed be executed in respect of a settlement deed?
Isn't it possible as a simple thing, a rectification, if only it's mutual, rectification is just fine, because it's one of those non-testamentary instruments which the law contemplates. Rectification in relation to property of whose value is more than 100 rupees would require to be registered. It is contemplated under section 17. So rectification deed can always be made, but it has to be a mutual mistake, a unilateral mistake. If only one party believes that this is what is the survey number you told me, then I say I'm not willing to do. It would require a court decree or modification before such a direction is given to a party. If both of them are willing, it can go through. The same way as about a cancellation. Both parties are willing to have a document cancelled, there is no problem at all. If only unilaterally somebody wants to cancel, it will be wrong. The same principle will apply here also to rectification.
Thank you, sir. Advocate Anand Kumar had raised his hand, so we have unmuted him, sir. You can.
Very good evening, my dear Lordship.
I'm ceased to be a lordship now. You just call me Kannan, sir, whatever it is. Tell me.
In one of the sub-courts, they insist for the compulsory registration of marriage certificate to admit the mutual consent waiver. This particular judicial officer is very, very strict about the same, and there are so much of pendency because of the same. Because in one of my cases, it's been 20 years, they have been separated. They have come for a mutual divorce now. And what is the last is that, and what is your valuable opinion on the same?
Om Prakash, will I be literally repeating what I was previously saying?
This has been answered.
Because we don't have compulsory registration requirement, Council. I forget your name, Anand. I don't think there is if there is a judicial officer who says that, meet him in his chamber and tell him, sir, where do you ask this, sir? It is not necessary. You tell him, don't embarrass him in court. Go and speak to him in the chamber and tell him that this is not correct, and say that in a respectful way. That's what it is, because there is no compulsory provision. If a marriage takes place through registration, such as a special marriage act can take place only through registration. Hindu Marriage Act does not contemplate a marriage could take place only through registration. The ceremony is attended, is provided there under section 7, how it is to be done. So for a registrar to say, register it and come, many, this Suvamari as a form of marriage, they believed, let us exchange garlands and register it. So therefore, it gave place, our Suvamari as a form of marriage gave an understanding to the importance of registration here in Tamil Nadu, much better than Punjab, like the place where I work. There will be no registration, there will be nothing. In fact, do you know, the birth certificate will not contain the name of the mother.
A is a vendor. Execute the sale agreement.
Somebody is talking?
Yes.
Yeah.
Yes. Mr. Karnakaran had raised his hand, so I have just unmuted. Karnakaran.
Yes, sir. Good evening, Lordship.
Good evening. No, Lordship. Yeah.
My question is that A is a vendor. He executes the registered sale agreement in favor of the purchaser. The time period was mentioned is 3 months. At that time, the purchaser simultaneously obtain a power of attorney through his manager, that is a C. That power of attorney clearly stating that the registered sale agreement, for the purpose of the registered sale agreement alone, the power of attorney will be executed, was executed. That is a clause is there. Now, after 6 months, after expiry of the 3 months, even after their purchaser not come forward, they are not issued a specific permanent notice, nothing else. Suddenly, later 6 months, the same power of attorney execute the sale in favor of the purchaser.
No, you said the purchaser also had a power of attorney. Did you not say that?
No, purchaser obtain a power of attorney through his manager, but the power of attorney reflected the power for the purpose of the sale, registered sale agreement alone. So the registered sale agreement class 3 months alone. The power of attorney also clearly stating that the purpose of execution power of attorney for registered sale agreement number also mentioned. In this circumstance, now the registrar is registering the sale deed because the power also invalid, the sale agreement period also over. Now the sub-registrar, we made a representation not to register the sale agreement, sale deed, but registrar saying that register the sale deed. That is the issue was involved. Whether the registrar having power on the expiry of the sale agreement, whether he can execute, register the sale deed. That is my question.
You have a direct answer through Justice Sundaresh order. This is typically the judgment which the court was dealing with. I'll give you the citation. This is available for you in 2016. There is a case where the asset reconstruction company case was a case where the sale deed had been executed by a person claiming to be a power of attorney. That power of attorney did not grant him the power to sell. There was subsequently an unregistered power of attorney which granted him the power to sell. But the sale deed made reference only to the registered power of attorney which did not allow to sell. If I were a lawyer, I would have argued differently. I would have said, now, like feeding the title, a power of attorney was there. This document contains reference only to a registered power of attorney. Later, there was a larger power, was what to state. Now, in that, the law which is made by the Madras High Court is the registrar is bound for admission of a document and presentation.
Yes.
Give that power for him to admit a document. Now, if the power granted a power only to execute an agreement of sale, and you have a sale deed sought to be registered on account of that, you must tell the registrar, don't register it because you don't have the power to do. Look at the power of attorney, it is only for agreement. If it doesn't do that, go by means of writ petition, cite asset reconstruction justice order, and try to secure an order of stay. So that is what I would say. Actually, the registrar is bound to see whenever there is a execution by a representative, whether that representative has the power. So therefore, he is not going into title. He is examining whether the instrument of which he comes before a registrar, does it grant him the power to execute the document? If it does not, then the registrar ceases to have the power.
Rule 27 also says like this, before registering, the scrutinize all the formula. Thank you so much.
Thank you. You have the answer. You have a better answer than
I had in fact sent you a long brief. Probably as a last participant, I unmute Mr. Vaidyanathan.
Yeah.
Yes, good evening, sir.
Good evening.
There is a circular issued by the IT of Registrar of Tamil Nadu facilitating the title holder to mutate his name with the revenue records, example Pata, for which the registrar should forward the register documents or titles transferred to the registrar office within the limitation of the property, within the limit of property, which was transferred over such title holder. But it was not followed by the registrar office. Shall the title holder can claim it as right based upon such circular?
See, there are powers under section 69 I said supervisory powers. I showed to you the hierarchy only for that. IG registration gives a circular. The circular is meant for obeyance. If he does not obey, you have a right to complain. In fact, the right to complain has been considered by some of the decisions. I'm not able to give to you right away, but you have decision under section in the book, which I have. Probably I'll be able to give that for you. That circular, if there is a circular, as far as the authority is concerned, to what extent it is enforceable by a third party could be a different thing. But for a subordinate is bound to follow that. If you don't do that, you can give a complaint to him. For that power is also given to the registrar, to give power of the registrar to superintendent and sub-registrar. That is available in section 68. You have right to complain to this section 68 commentaries and case law on that you will find that allows the district registrar to ensure that any complaint must be suitably redressed. Then if you have a problem, if he doesn't do it correctly, then you can tell him the circular is not being applied by him. Please direct him to do something. He will do, and it will happen for you.
Thank you. Thank you.
May I request Siva Shanmugam to take over?
Now may I request Mr. S.R. Sundar to give you a vote of thanks, sir.
Good evening, my lord. I
Hi,
have
Sundar.
the opportunity to give a vote of thanks on behalf of the study circle. And Om Prakash and other members like Siva Shanmugam and Rishikesh are doing wonderful service and educating us in very, very many interesting field. And I very heartfully thank on behalf of the study circle. And everybody knows that you are the person who appeared in Dr. Billy case, where 22A was struck down by your court.
Do you know? And who instructed me? Did you see that?
Justice Anand Venkatesh, as he then was, I mean, he was instructed you in that case. 22A, where Dr. Billy, that's what I was about to mention, the two personalities who appeared in this case are on the benches. And I also had a very interesting case in Punjab and Haryana, that the Semarjit Kaur case, where you very well dealt that the registrar cannot go into the title. Where all the, and I'm very thankful for, and also this Naveen Kumar case about the scope of 47A with our court. I have two more case laws I want to tell all the members. That is, one is 2008 CTC 43. That is Radha Ammal case, which is on section 49 of the Registration Act, where an exception was made about the admissibility. And 2009 1 CTC 629, the exception to section 17, where you have carved out and it has been placed. I thank you very much and for this wonderful and also addressing all the volley of questions to all the junior members of the bar and other members of the bar. It was a very, very wonderful session. I thank you, my lord, for sparing time for us and educating us in a manner which you always do very well. Thank you, thank you.
Pleasure.
And also thank, yes. I also thank Senior Advocate Yashodhardhan sir and Rajendra Kumar for looping in and bringing you for having this wonderful session. And I thank Sivaji sir. I'm seeing him after a long time. Before the lockdown, we met and all other senior members. I also had Justice Pushpa Satyanarayana was here for some brief moment. I also thank their lordship for attending this and all the young members of the study group and senior members for wonderfully interacting and asking very, very valid questions, which all educated us. Thank you, one and all. Thank you.
1 minute, Raja P puts it in the chat box. Tamil Nadu registration of marriage, registration is compulsory now, he says. I am not aware, and that is after I left this place, I have not kept pace with it. So that probably my comment was about registration of marriage must stand modified to a confirmation whether in Tamil Nadu there is a provision for compulsory registration of marriage. To my knowledge,
yes, sir.
So post that date, probably the registration certificate becomes mandatory.
Awesome.
So that is Act 21 of 2000.
I'll take you.
Which is published in the Gazette with effect from 7th August 2009. That is pursuant to the Supreme Court judgment of Seema versus Ashwini Kumar.
Correct. There had been a direction to all states to come.
Yes.
So I'll take your leave. Thanks to all of you to have given me this opportunity to connect to the only bar I love. So thank you very much.
Thank you, sir.
Thank you, sir. Thank you.